Mr. Kothari, the CJI has told the district administration of Sambhal that there should be a peace committee be formed and peace should prevail. And at the same time, the CJI says that, very importantly, that the Muslim side has the right to be heard, that the petitioners have right to challenge this order.
Well, absolutely. I mean, in a court of law, anybody, howsoever absurd the proposition may be, or argument may be, they have a right to agitate their own grievances. And then it's for the court to decide whether the argument has any merit or not. So if the Muslim side feels that the order which was passed by the lower court was perverse order, was not without, was not with merit, then in that event, the court has a right to, hear them out. And a peace committee needs to be formed, because if 4 people are killed for the survey that has taken place, and, this is not going in the manner in which it should go, which is peacefully. And let me put up a counter argument as well, that if the Muslim side has got an argument to make, likewise, the other side also has got an argument to say that surveys need to take place. What is the harm in surveys taking place? Let the truth come out, and the truth can come out only when there is a survey. So I don't think there should be any objection to any surveys ordered by the lower courts. So the Supreme Court is right in its own breath, stating that yes, the petitioners have a right to agitate themselves, that is the Muslim side. But in the same breath, I may say that the survey should also take place, and a peace committee needs to be formed, because this issue, although tenuous and also stemming out of religion naturally, because it's a Mandir Masjid issue, obviously is bound to be fraught with tension. So a peace committee needs to be formed, and in a civilized country like ours, in a democratic country like ours, both the sides have to be heard, and both the sides have to be heard equitably. And then an order has to be passed by the Supreme Court. So whatever the decision the Supreme Court takes today or has taken today is going to be based on these set of arguments.
Right, and also very importantly, if you could help us understand when the CJI says that it is not under Order 41, so you cannot file the first appeal. And Ahmadi, representing the Muslim side, goes on to say that this is capable of great public mischief.
Right, exactly. So if the court is of the view that this is not under Order 41, so you cannot file the first appeal, so then wait for your turn. And then, obviously, Ahmadi, who's the public, who's the Muslim side, is saying that this is capable of great public mischief, in the sense that what he's trying to say is that in every situation, wherever there is the Hindu side thinks that there was a mandir before, and now that a masjid is standing there is a tendency for the Hindu side to come and say that for every single masjid that is there, to say that there was a mandir before. So that is his argument. But that argument or that statement should not be taken very seriously, because that is an argument that somebody would make because he or she thinks that that is possible. So that is what he implies or means by the word public mischief. Likewise, the other side, which is the Hindu side, will also make an argument saying that this is also a great public mischief, that you don't allow surveys to take place, and say that the Places of Worship Act doesn't apply, and then go on to say that this is a monument guarded by the ASI. So obviously the Archaeological Society of India. So that means this should not be questioned into. So that kind of an argument is again suspect or susceptible to public mischief. So both sides are going to present this argument and say, and let me tell you, in my own personal view as a lawyer, and as possibly what the court is going to say, that survey should take place, because there is no harm in surveys taking place. And that is the way it has to be. Let the survey come out, and if the survey says that no, there was never a mandir before, the matter ends.
Right. No, in fact, the latest update is that the Supreme Court has asked the trial court not to proceed in this suit, against the Sambhal Jama Masjid till the Mosque Committee's petition is heard. It is listed in the High Court. So that means, Mr. Kothari, that first the matter will be heard in the High Court, and then only we can see this survey being conducted. Or how do we really go about this?
So what this means is that until and unless this petition, which is challenging the order of the trial court, which has possibly talked about a survey, so until and unless my petition is heard before, so you dismiss my petition first. Let the High Court dismiss the petition of the Muslim side. Then the trial court, it goes back to the trial court. But if the High Court says, which is a court higher in the hierarchy than the trial court or the lower court, in that sense, if it says that no, the petition is valid, yes, there should not be a survey taking place, then automatically the matter before the lower court does not proceed. But until there is a decision on this, the matter in the lower court should stand stayed. That means there should not be any progress in that matter. That is what it implies.
Okay.
So
Right.
in simple terms, say for example, if there is a divorce being taking place, or if there is a divorce petition being heard in a marital court, and if the other side says that, by the way, there is something which needs to be brought before the High Court, and to say that we two were never married in the first place. Or, some sort of a counter argument is there which only the High Court can hear. Then the High Court will say that, okay, before this divorce petition is heard in the matrimonial court, let me, as the High Court, hear this out to say that these people were never married in the first place. How is it that this is there as in a matrimonial court for divorce? Because divorce presupposes marriage. And if for any reason, if this man is going to the High Court and saying that we were never married in the first place, it is an absolutely bizarre argument. Maybe it's a delaying tactic. Maybe he doesn't want a divorce. So he comes out with something, he cocks up. He cooks up something. So that is exactly what the implication here is. I'm not saying this is cooked up, but I'm just giving you an example.
Yes.
That in the matter of hierarchy, this is where the High Court will have to decide upon this first.
All right.
And then the trial at the lower court will progress.
All right. Thank you. Thank you so much, Mr. Swapnil Kothari, for in fact shedding some light on that and help us understand what has really happened in this hearing of the Supreme Court. I'll go across to Riyanka once again. Riyanka, tell us more updates that you are getting in from the Supreme Court. What is the bench? What has the bench said finally?